Okay, welcome to Lower Makefield Zoning Hearing Board for October 5th, 2021. We have 4 appeals tonight. We have one guy running late, but we do have a quorum here, so we can get started. But remember, even when he comes, there'll still only be 4 if he comes. That's an even number. Ties go to us. So keep that in mind. Right now, it's just 3 of us. We don't know when he's coming. Hopefully he will. But we could get started right now. Appeal number 1, or it's number 3 on our list. Number 1 is appeal number 21-1930, Andrew Evans. If you want to step up and get sworn in the meantime, Adam, is there any exhibits you need to enter in?
Yeah, nothing crazy. We have the application as A1, the site plans as A2, B1 proof of publication, B2 proof of posting, and B3 is the notice to the neighbors.
Okay. All right. We swear them in. Both of you. Now listen, you got to speak into the mic while we're speaking, only one at a time. If you want to take that one, because that guy on the back behind that glass will yell at me. You can take it out of there and sit.
Andrew Evans.
There you go.
Anthony Rossi. Yes, ma'am.
All right. We got through that. Tell us what you want. What are you trying to get?
So we're requesting a variance to build a sunroom on the in the backyard of our house. And I believe the non-permeable surface limit is 18%, and we're looking to go slightly over 20%.
All right. I noticed, go ahead. Were you going to say something more? Go ahead. I noticed on your application, you do understand there's a mitigation issue with it before we get that far. And you do say you will do whatever's necessary if you don't detail it on the drawing. So just let you know that if it does come that way, we will let you know or tell you in the motion that you'll have to make sure you come up with some mitigation plan that's okay with the township engineer. Any questions?
Further clarification of that is that we would be looking for some sort of infiltration system as opposed to using trees, because we just don't know the trees get maintained, the next homeowner chops them down. So we look for the mitigation by infiltration.
Right. Yeah. Understood. Tony, do you want to cover that?
Yeah. So what we had been planning on, and I spoke to a gentleman the last time we came to get all the paperwork straightened out, is that we're going to do a seepage pit that'll take over and handle the watershed off of the new structure. We're also going to do some rain barrels, just supplementary, because they kind of want them to do a lot of gardening. It's not going to be for the mitigation. I mean, it'll help slightly, but it's really going to be the seepage pit that we've deemed is probably going to be 3 feet wide, 3 feet deep, and about 12 feet long in order to handle the volume of runoff that we're going to have. And when the architect, we have everything current here, but if I need to have some kind of engineer drawings or drawings, drawn up to show that for permitting and planning and all that, we will have that as needed.
Okay. Like Pete says, we prefer the mitigation to be something permanent.
Yeah. Yeah. I
If you want to go over and above with rain barrels, feel free.
Sure.
Yeah, because they don't last. Yeah.
Yeah.
Okay. Anything else? James? Okay. I'm okay. Is there any, Barb, you participating in this?
No, township.
Township's out. Anybody in the audience want to say something? Anybody? Nobody? All right.
Anybody online?
Oh, anybody online? Nobody. It's a dead issue. All right, somebody make a motion.
Make a motion to approve appeal 21-1930, subject to mitigation of stormwater back to 18% effective impervious area utilizing infiltration methods subject to approval by the township.
Do I have a second?
I second that motion.
Any discussion? Nothing? All those in favor, say aye. 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 All those opposed? No, since no one's opposed, we have a 3-0. You are granted your variance. Good luck. Remember, bring drawings that show mitigation to what you to bring it down to what it is.
Yes, I'll
You can work with Jim. He'll probably let you know a little bit.
Yes, and I'll work on getting that drawn up right away.
Okay, thank you very much.
Thank you, guys.
All right, next appeal. Appeal number 21-1931, Sam Ramsden. I'm sorry if I messed that up. Step up. One. No. That name, it's too many vowels in it. I'm not gonna try. So, okay, you guys, let's get sworn in. You can grab the other mic, Matt.
You do.
You can see. Whatever you want.
Matthew Petrowski, architect. Sure. P as in Paul, I-O, T as in Tom, R-O-W-S-K-I.
Okay,
I'm Sean Ramsden, the homeowner.
all right.
With a mark?
Yeah, you have any exhibits?
Yeah, same as last time. Application is A1, site plan is A2, B1, proof of publication, B2, proof of posting, and B3, the notice to the neighbors.
Okay. All right, guys. Matt, do you want to?
Sure. We're here this evening requesting two variances. They're both dimensional variances, and one is for the front yard setback to be reduced from 50 feet to 45 feet, and the other one is the rear yard setback to be reduced from 50 feet to 45 feet. The front yard, we'd like to construct a foyer on the front of the house. Right now, you open the door, there's no roof. You just come right in and you're right in the house with your muddy boots. And so we'd like to construct a foyer. We feel that what the request is de minimis in nature, in that any pedestrians or anybody driving by will not realize that we need a variance to construct this foyer. Even though the setback is 50 feet, from the front of the proposed foyer to the line where the macadam starts is actually 60 feet. So and the street has a little bit of a curve to it. So the houses next to it actually look like they're closer to the street than this house. So to the point that I brought up, no one is going to know that we would need a variance to construct this, the foyer. The rear yard setback, we're proposing a deck which is 15 feet by 15 feet. We looked into a patio. Unfortunately, if we put a patio in, we would be here for an impervious variance. We felt that a dimensional variance would be, I don't want to say easier, but less relief than an impervious variance. If we made the deck 10 feet versus 15, you really can't sit a table on there and some chairs. Also, the deck is only going to be about 14 inches above grade. So it's not like it's sticking up in the air where the neighbors are, have to put up with people, watching over them and, like a tree house. No one's going to feel like they're in a fishbowl. So, and again, we feel that the rear yard setback variance is also minimal in nature. No one looking at it is going to realize that we needed a variance to construct that deck.
Mr. Petrowski, the soil or the soil underneath the deck will remain pervious?
Yes, it will.
Board members, anything to say? Nothing? Nothing?
It's clear what he's looking for.
Yeah, to me, I just wondering. Barb, are you participating in this?
No, we are not.
Okay. Anybody, public comment? Virtual? Nobody cares about you. Nothing's changed, Mr. Petrowski. I see it as very minor. setback change, 5 feet front and back. I got it. Okay, we don't have anything like that. Any opposition? No public comment? So we make a motion.
Make a motion to approve appeal number 21-1931 as submitted.
I'll second that motion.
Okay, any discussion? All those in favor? Say aye.
Aye.
Aye, all those opposed? There's no one opposed, 3-0. Motion is granted.
Thank you.
Thanks.
Thank you very much.
Take care. There you go.
Yeah, that's the file. Yeah, 81.
Okay, moving along. See, yeah. Oh, they're virtual. Okay. Okay. Okay, next appeal is appeal number 21-1932. And the person is Lucy and Albert Giaconovkova. Jesus, I ruined that out. Anyway. Giancova, good Italian boy, and I still can't say it. All right, if you guys will get sworn in.
Yeah, well, good evening, Joe Blackman from Whistler Pearlstein here on behalf of the applicants, Giannakovas. I'm sure that Mr. Solicitor has some exhibits, but if and when appropriate, we can have John Genovese, the project engineer, sworn in. So I'll take my cue from you, Mr. Flager, on that.
Sure. I'll mark the exhibits. We have application as A1, site plans as A2, the reasons for the requested relief as A3, property deed as A4, B1, proof of publication, B2, proof of posting, and B3, the notice to the neighbors.
Right. As I said, Joe Blackman from Whistler Pearlstein here on behalf of the applicants, Albert and Lucy Giannakova, with respect to their application concerning the property located at 1 Sutphen Road. I believe I have the capability to share my screen. I'm just gonna, there we go. The subject
Joe, I
property.
need this, Joe, I need
Yes.
to swear the witness in, please.
Yeah, sure. We can go ahead and swear if that's Mr. Campbell. It sounds like at least I will. John Genovese is going to be my witness. So we.
John, do you solemnly swear the testimony about to give will be the truth, so help you God?
I do.
All right, thank you.
And can you just state and spell your name, John, while we got you?
John, my name is John V. Genovese. That's Geno, V as in Victor, ESI.
Okay, I'm sorry. I was going to ask you to proceed with the explanation of variances you seek to get.
Yeah, absolutely. By way of brief background, the subject property, which is depicted on the plan before you, which was submitted with the application, consists of 2.1 acres and is presently improved with 2 single-family detached dwellings, both of which are depicted on the plan. Applicant proposes as a part of tonight's application to subdivide an approximately 18,000 square foot lot from that existing property, which would precipitate or rather necessitate the need for 2 items of relief, with which Mr. Genovese will elucidate us all upon momentarily. I guess having already been sworn, John, you are a professional licensed engineer employed by Tri-State Engineers, is that correct?
That's correct.
And you are responsible for the preparation of the plan, which is before the board presently and which was submitted with the application.
That's correct.
And this is an existing features plan, correct?
Yes, it is.
And this depicts the current state of the property with 2 single-family detached dwellings and various accessory outbuildings, correct?
That's correct.
And the property maintains frontage on Makefield Road and Sutphen Road and Fayette Drive. So that's actually a tri-frontage property, quite unique. Is that accurate?
That's accurate.
And the property that is the subject of tonight's application was created via a 1951 subdivision. Is that correct?
That's correct.
And I'm sorry, let me flip through. that plan of subdivision, which I guess I don't believe this plan of subdivision was submitted with the application, Mr. Solicitor. So if we can mark this as applicants 1 or whatever the proper protocol is.
A5 is what we're up
A5.
to.
Oh, they're all A's. Okay.
Yeah. So that would be the subdivision plan?
Yeah, the 1951 subdivision plan for Green Acres. Mr. Genovese, you are familiar with the plan that has been marked for identification as A5, is that correct?
Yes, I am.
And this plan depicts an approximately 29 unit subdivision, and as is evidenced on the plan, was recorded in 1951, is that correct?
That's correct.
And for purposes of orientation, the large parcel at what I'll call the lower left-hand corner of the plan is the subject property, correct?
Yes, it is.
And the dimensions shown on the plan for the various 29 lots which are created depict lot widths ranging from 90 feet up to 102 feet, with the majority being 90-foot widths. Is that correct?
That's correct.
You're also familiar with the plan, the variance plan, which has been submitted with the application, correct?
Yes, I am.
That's before on the screen presently, I believe, marked as Exhibit A2 previously. This plan depicts the proposed subdivision of an approximately 18,000 square foot area depicted as Lot 2, correct?
Correct.
And that Lot 2 would have a 95.5 foot lot width. Is that accurate?
That's accurate.
And what is the minimum lot width in the R2 zoning district presently?
That would be 110 feet.
But the 95.9, or excuse me, the 95.5, despite being less than 110, is nevertheless larger than the 90-foot lot width, which we saw for every other lot on Makefield Road, correct?
That's correct.
So the subject or the proposed lot would in fact have a greater lot width than those on Makefield Road, correct?
That's correct.
And the second item of relief, which we are seeking this evening, has to do with the 7-foot setback for the proposed accessory garage. That's this existing structure 1, correct? That's depicted on the plan?
That's right.
And again, that is an existing structure now, correct?
That's right. Yes, it is.
And the proposal would be to incorporate that as the detached garage for the proposed dwelling on Lot 2, correct?
Correct.
However, the existing nature of that garage prevents us from relocating it or moving it in any way such that it is affixed to its current location, correct?
Correct.
And we also have a 15-foot minimum side yard setback for the existing dwelling on Lot 1, correct?
Correct.
So explain to me the interplay between those various dimensions, because right now they probably just sound like a lot of gobbledygook. We have a minimum 15-foot side yard setback that we need to adhere to, correct?
That's right. So we set that boundary between Lot 1 and Lot 2 with that 15-foot side yard as required by the ordinance. And when we set that boundary at that point, we have the 6.99 feet to the existing garage.
So in order to have a compliant side yard for the Lot 1, we are left with a resulting 7-foot setback for the existing structure that would be the detached garage, correct?
Correct.
You're obviously familiar with, or I guess let me strike that. Are you familiar with the general nature of the properties within the vicinity of the subject property?
Yes, I am.
And did you prepare this plan, which I will mark for identification as Exhibit A6, which is an aerial with the proposed subdivision plan or zoning plan overlaid atop it?
That's correct.
And are these grade lines the lot lines as created by that 1951 subdivision?
Yes, they are. The ones across Makefield Road are of a different subdivision, of course.
Okay, yeah. But so the grade lines, regardless of the creating subdivision plan, reflect the current property boundaries for those properties in the vicinity.
Yes.
And they are all of a similar width to the 95-foot lot width that's proposed for our proposed Lot 2, correct?
Correct.
And each of those lots is presently improved, as you can see from this aerial, with a single-family detached dwelling. Is that accurate?
That's accurate.
So is it fair to say that the proposed Lot 2 would be very much, or excuse me, I'm sorry, the proposed Lot 2 would be very much in keeping with the character and nature of the lots in the vicinity?
That's correct.
And as a result, is there any reason that you have to believe that there would be any detrimental impact to the neighborhood as a result of the creation of that lot?
I believe there would be none.
And in fact, this is the minimum relief that is needed to afford a reasonable use of that lot, as evidenced by the fact that any greater relief would in fact create additional relief for the retained lot, correct? That 15-foot side yard setback that we're attempting to maintain compliance with for the existing dwelling.
That's right.
All right, so let me sum this up. From what I see, the lot, it was divided in two lots in 1951. You want to put a house on there, but you need some relief. Instead of being 110-foot width, you're asking for 96-foot. On the lot 1, you went to the 15-yard setback, which was minimum, and that lessened your setback for the garage to 7 feet. Am I correct here so far?
You've said it probably better and more succinctly than I, yes.
There you go. So that's it. So that's what you're looking for. Is there any other issues, impervious surface issues on this? I don't think so.
Now, we're entirely compliant with all building coverage, impervious. The one additional thing I would add, however, is that obviously this is or will be the subject of a subdivision. And as a result, sidewalk will be installed along the entire frontage of both, over 600 lineal feet of sidewalk along both frontages, as well as stormwater management facilities, which, as you can imagine, from a 1951 subdivision were not contemplated at that time. So there are those two added benefits for this plan, which is, with that added information, no, there's nothing further that the applicant has. I'll certainly make myself or Mr. Genovese available for any questions, and otherwise move my exhibits into the record.
So I'm sorry. So you're adding a sidewalk out front. Is that what you said there?
Along both frontages, both Makefield and Sutton, yes. It's over 640 lineal feet, yeah.
Barbara, are you participating in this?
Yes, I am.
Really?
Yes, in this one. I just have a couple questions, if I may.
Sure.
So I just want to clarify, the property is still one tax parcel numbered presently, is that correct?
Correct.
Yes, if that's presented to John, yeah.
Okay. And you're just carving out a piece to put a new proposed dwelling on the new lot number 2, correct?
Correct.
And because of the location of the existing house on lot number 1, the subdivision can't make the 2 proposed lots equal in width. Is that correct?
That's correct. We set that boundary between, as we said before, between lot 1 and 2, so that we would comply with the side yard setback for that existing dwelling.
So the 15 feet side yard setback is more applicable to the house on the new lot 1, which is what created the issue for the other lot.
Correct.
Okay. And at this point, you said that, or Mr. Blackburn indicated that there were 2 existing residential dwellings. Both of those will continue to be located on lot 1?
Yes, ma'am.
Are there 2 separate families living in those properties, if you know?
I don't know.
But the new lot 1 will still be treated as one residential property, correct?
Correct.
Do you have any idea if there's going to be use of the second residential dwelling for someone other than family that would be living there?
I wouldn't know.
If I may, Mr. Blackburn, the reason I'm bringing up the questions is I hate to see, and I don't think the township would be in agreement, that the second dwelling on lot 1 be used as a rental property for some third independent party. And what assurances can be given to the township that that won't occur?
Well, I can happily call Mr. or Mrs. Giannakova if you'd like to maybe expound upon that, Mrs. Kirk, if that's probably more appropriate than me speculating, so.
Okay, so your clients, the property owners are available?
They are logged in, I assume. I see their names. Albert or Lucy, are you with us?
Yes, I'm right here. I'm right here.
Can we get, sounds like Lucy, can we get you sworn in real quick, please?
I'm sorry.
Can we have you sworn in?
Yes, sure.
Ma'am, do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes, I do.
Can you state your name?
Lucille Giannakova.
And you are, along with your husband, the owners of the subject property?
Yes.
And you heard Ms. Kirk's inquiries about the current use of the two existing dwellings. Can you expound upon how those existing dwellings are currently occupied and used today?
Yes, we have relatives live there.
In both of the dwellings?
Yes.
I have nothing further, Ms. Kirk, if you.
If I may, would your client, if the board were inclined to approve the variance request, agree to a condition that the property would be deed restricted to preclude it from being like each of the two homes being rented individually to two non-related families?
Lucille, if that's.
I don't know if that's legal to have a deed restriction like that. Is it?
Well, we're not saying it would just be that a single family unit needs to, or a relation needs to exist between the occupants of both homes on the dwelling.
Okay.
Now, let me clarify. Neither of those are for what we refer to as a transient rental, correct? You're not running an Airbnb.
No, I'm not running a boarding house or anything. No.
Ms. Kirk, I mean, candidly, I think we can probably fashion something that would address your concerns, or rather the township's concerns. I'm hesitant to agree to a omnibus requirement for a familial relation, just based on the brevity of time which we've had to discuss that with my client. But is there would it be amenable that we discuss, a condition that we discuss some sort of use restriction that would be acceptable to your office and ours, just to give us some more breathing room to explore that as opposed to making a decision on it right now?
I don't think the township would have any opposition to a condition of the nature that some sort of restriction be placed on Lot 2 to limit the use that would
Lot
be
1.
acceptable to both. Lot 1. Lot 1 that would be acceptable to both the property owners and the township to prohibit a use in the future for a boarding house or something of that similar
transient
nature.
rental. Yeah, I think.
That's fine.
Yeah, we can certainly commit to that. I appreciate the willingness to, allow us to do so. That condition would certainly be acceptable. We'll certainly figure something out.
That's all the questions I have. But my mistake, yeah.
I'm sorry. There you go. Step right up. Sit down there. You can grab the other microphone. You need to be sworn in.
Hi,
Did you give your names?
James Scammell. I live directly across the street from these properties you're discussing. 1705 Makefield Road.
Your name? Did you give her? Hold on. And you're James. All right, James, proceed.
So I'm listening to this presentation. I wanted you to know that the neighbors on either side who also are directly across from these properties were quite alarmed when we got the notification, and they are online, I assume. Some of the statements that were just made, I find surprising. First of all, the existing garage is a shell with a collapsed roof. You know, it's unusable. I don't know how they can claim that, I guess it's an existing structure, although unusable. The other thing is the statement saying that these places are rented to her relatives and family. There are two existing buildings. One of them has two different renters in it, across from the Lutheran Church on Sutphin. And then the house directly across from us has an African-American, not family, a number of elderly and then younger people. And every day there are multiple cars arriving. And so I'm not sure exactly what the use is. It doesn't seem as though it's a domicile.
And this is on the existing lot, right? You're saying?
This is the lot that the one that this is being taken off of. Yeah, the one.
The house that fronts on Makefield Road across from you.
Yeah. Okay. Previous to that, they had a family in there, I believe from Virginia, I'm not sure, but for about.
If I can interject, I'll object at this point. I'm not sure what any of this has to do with the relief that's actually being requested, which is limited to lot width and the setback of a accessory structure. So I'll just note that for the record. I'm sure that the board will allow Mr. Scammell to continue with it.
So my objection to that is the existing garage thing. But,
So the existing,
the statement about the usage, our concern was that it was going to be another rental property. And that's really changed the nature of our neighborhood. We had some pretty bad renters in there for approximately 10 years that they set up a gym in the garage. They put the garage door up. They'd had giant speakers. They'd blast music out during the day. The husband had a very loud car that he would start up at 5:20 every single morning and let idle. Our bedroom happens to be directly across from that garage. Everybody in the neighborhood heard. So the thought that these are rental units has us really concerned, because
You're saying
there's no
right
quality.
now, the house on lot one and the other house on lot one, there's not relatives living in the other existing family.
Right, but it is relative to the statement that, are you intending on building a house to be used as a rental property? That's a concern.
And they said, no, we can probably put that in it as a conditional use for that, I think.
Correct.
So
If I may say something.
Hold
this
on,
is Lucy
no,
Gem-
Lucille,
Yes.
we'll save it.
You get a shot, Lucille, hang on. Go ahead, James.
My concern is that she's saying that she's renting the family. We've seen no evidence of that. And in fact, I talked with her when the previous renters left, and we told her that, you know, we were living a nightmare for the period of time that they were in there. And she indicated that her husband had lost control of it and, you know, had not really just let people in to rent and didn't really examine who was renting.
Mr. Scammell, can I interject? And you might find this helpful. So Ms. Kirk stated that as a condition of approval, there may be a deed restriction on lot one, that it would have to be familial members who occupied those homes.
The question was asked whether or not who were occupying the rental.
No, I'm aware, but I'm saying actually approval of this with that contingency could be favorable to you and your quality of life if they are indeed familiar members who are in there per deed restriction.
If that's the case, I mean, if a single family is moving in there and this is going to be their home, I object to nothing about that. It's the fact that we would have now 3 buildings that are rental properties across the street. And you never know, you know, they have no invested interest in.
No, you're making great points. So I'm not contradicting you. I'm just letting you know that Ms. Kirk suggested that there'd be some land use controls over the existing two houses now that might be beneficial to the neighborhood. The other thing is, I wanted to ask you, you mentioned that the existing garage was a shell. Is that on the proposed lot as you see lot 2 of the plan?
That's correct. Yes, the garage that I'm assuming Mr. Scammell's referring to would be the one that would be repurposed for use for lot 2.
Correct.
Have you seen the condition of that garage?
I'm sorry.
Have you seen the condition of that garage?
Have I seen the condition of the garage?
Or can we ask the Giancomas, is the condition of the garage on the proposed lot 2 in what might be considered shell condition?
It has a hole in the roof. Our plan is to keep the foundation and relocate the garage door to the opposite side of it. So we would reframe the side with the garage door and we would put it a new roof.
Yeah, I mean,
And we
the
didn't do anything until we got our approval, you know?
I mean, candidly, the proposal is to ameliorate exactly the concern expressed by Mr. Scammell, which is the condition of the garage. So to the extent it is in a current state of disrepair, I think the proposal is directly to address, or rather the remedy is proposed as a part of this application, which would be specifically to address and repair that garage. So I don't.
Yes, that will be rebuilt.
I didn't understand that. Can you repeat that?
I said to the extent.
I heard you. Was it Lucille?
She just said yes.
Oh,
So we want to totally rebuild the garage. We didn't want to do anything until we get an approval.
I understand. So let's go back. Garage, you have an issue with, it's falling apart. They say they would rebuild it. Would that be okay with you? I'm just asking that particular question. You said, Mike.
My concern is more with what they're doing with this property.
Well, they want to.
I know that this whole acreage is an investment for them, and that's fine, but we're bearing the brunt of some of that stuff, and we need to know.
What brunt is that besides the loud neighbors? That's not a zoning issue, though. That's not a zoning issue.
No.
That's a township issue. Have you called the township about this particular issue?
No, we thought about calling the police on several occasions, but.
And why didn't you?
We didn't want to start something with the neighbors.
You're here. You're doing it now. Listen, I understand, but I gotta have something a little bit more than that. I don't know what the other board members feel, but I'm feeling you're not giving this guy use of his land. He has a minor variance he's asking for from 110 to 96. And Barbara will insist on having the clause in there that they have to stay with renters in lot 1. And if they don't, they can't do that. So they're answering that question. And lot 2, what do you want for that? That the house they build on there goes to certain people? Or I mean, what do you? So they're addressing every one of them.
If you're asking for a
And
variance,
if am I wrong here?
you're asking for a variance.
Mm-hmm.
So in order to do that, you need to examine what the use of the building is going to be. And
The hell?
that was addressed by Ms. Kirk about whether a family was going to occupy this, whether they were going to sell that property and sell the house when it's built. I have no problem with that. It's the rental aspect of all of these houses. In addition, they have a large property on the corner. And is that?
We're only concerned about this property. Stay with this property, but let's maybe understand, maybe I'm missing something. I thought Barb,
Well, maybe I can address.
yeah,
Mr.
maybe you can make it a little clearer because I'm a little confused.
So the township is concerned that the 2 existing houses on what will be the new lot number 1 could be used for more than just residential purposes, which is why we want to make sure that there's some sort of restriction in place. So it doesn't become a large commercial unit, or it doesn't become an Airbnb or something like that. The fact that these 2 properties are going to be created doesn't prevent the property owners, whoever they may be in the future, somebody could come in and buy lot number 2. There's no requirement that the owner has to live in the house. That can be rented to other people. So the problem you're facing is not so much the current property owners, but the occupants of the home, which is something you probably do need to speak in greater detail to the township, because there may be mechanisms the township can use to get these people that might be rowdy to calm down. It's not any different than if somebody who comes in to buy lot number 2 and decides they're going to live there, they could be a rowdy neighbor that you may not be able to control. So I understand the concerns that you have, which is why I raised the issue. But at the same time, if you're having issues with the current occupants of the property, you probably should call the township and talk to somebody, because there's a code enforcement officer that can go out there and check to make sure things are on the up and up. And if there's a problem, issue notices of violation. So there are mechanisms in place that can help maybe alleviate some of the issues.
Anything else? Is there
I would
anybody
like-
on virtual? Okay.
I would like to address what, I believe his name is Mr. Scammell, is that his name? The neighbor across the street. We had tenants that we asked to move in 2018, the guy with the loud car. We asked him to move. They were there 7 years. He moved in 2018. The house has been very quiet since then. He can't say that he saw anything. Right now, I have a cousin with special needs that's living in that house. There are 2 special needs persons with the African Americans or the CNAs that rotate to take care of them. And it's very quiet. They can't say they hear anything over there. And that is a situation. And why it would come up that they were African American is really
I have no idea.
Right. And you know what? I'm not adverse to selling this property someday, maybe. I just, right now, I wanted to do this. My son was looking for a place to live, and I wanted to put a house there. I bought that. When we bought it, the realtor told us that we could put 6 lots there, which I'm not asking for 6 lots. So that's where we are. But nobody could say it's noisy over there now.
Okay, thank you.
Thank you.
All right, who are we bringing in now? Can you give us your name, be sworn in?
Cheryl is coming in.
Cheryl, okay.
Yeah, I'm
Cheryl, you
Cheryl
need to give your name and be
Varga.
sworn in.
Cheryl,
And address, thank you.
Amy, you need to
address,
give your name.
Cheryl Varga, 1703 Makefield Road, Yardley, Pennsylvania.
And do you solemnly swear the testimony about to give will be the truth, so help you God?
I do.
Can you spell your last name for me, please?
Varga, V as in Victor, A-R-G-A.
Thank you.
Okay. Do you have something to add?
Well, my concerns were basically the same as the Scammels. I was concerned about the dwelling being built and how it was going to be rented, if that was indeed the case.
And we cleared that up with Mrs.
Yes,
Kirk's
you have.
suggestion. Yes. So is there anything
yes.
else?
That is all.
Okay, thank you very much.
Thank you.
We have one more. Okay.
Eric is now in the room.
Eric, name, address, please.
Eric DeBraccio, 1707 Makefield Road.
Sir, do you solemnly swear the testimony about to give will be the truth, so help you God?
Yes.
You spell your last name for me, please?
Yeah, D-I-B-R-A-C-C-I-O.
Can you repeat that again?
Can you repeat that
Yes,
spelling again?
I have it. It's D-I.
Sorry.
D-I-B-R-A-C-C-I-O, 1707 Makefield.
Okay, if you have something to add, now's the time.
Yes, I too was initially told when they moved in across the street that their family was going to be there. And that was pre-dating it turning into a rental property. And since I haven't seen them there except for improvements. So I'm wondering what sort of checks and balances are there that the additional property will not be a rental property after potentially being approved and built?
Well, you can't prevent a guy from putting a house up and then deciding he's got to move to Colorado and he's going to rent the home. There's nothing
No,
to
I
do.
understand that. I understand that, but when you put up,
Can you speak? Excuse me.
anywhere from,
I can hardly hear you. You need to speak up a little louder.
I understand that, but when you move into a neighborhood and you shell out a down payment for a residence and where you want to basically raise a family, and you have a complete unknown variable across the street from you consistently, is that something that creates a positive environment in your neighborhood, or the exact opposite? And just like you heard from some of the neighbors, we had to live with loud cars up and down the road. We have to believe when they first moved in that this was going to be a home for their family, which it was not. And they actually stated initially that it was intended to be a residence for family, and they lied. So why is all of a sudden you're going to all of a sudden believe something that they're saying now when that hasn't been the case? And I'd like to know how many rental properties they have before all of a sudden we're going to believe that this is not intended to be another.
Well, we can put a deed restriction on the property in order for them to get the variances they want. So again, and I know you said you heard noises as they did. And again, we have a mechanism for that to call the township. But we can add restrictions that are forced to do certain things to an extent. Like those two houses there that they're using now, lot one would stay as long as their relatives there, and they couldn't. Once that ended, that would be the end of that. The other house on lot two, there's nothing that can restrict it if it's approved with the variance changes of the setbacks. There's nothing that we can do to tell him he can't rent it. That's just not fair. Is there, maybe I'm missing your point, but if I did.
Yeah, my point's very clear. You're saying the deed is approved under the assumption it's not a rental property. I'm asking very clearly, what assurances do we have if it's after the fact?
The fact that it's going to be in the motion, and that's how they have to use it. If I'm understanding your point, you said, how do we know, how can we be sure? On property one, we can put it in the motion that has to stay that way. And for the future, property two, we can only grant the variance of the reduction of the setbacks. That's all we can do there. There isn't a major change in the setbacks on lot two, maybe 14 feet, I think it is. And the garage we can put that in there. They have to tear down the garage or rebuild it. We can do all those things. Now's the time. But we can't do nothing about noise. If it's all done, everything's done, as we say, we got deed restrictions in place and they're noisy, there's nothing we can do. And it wouldn't be, you have to just call the township. Assurances, we can do a really good job, but at 100%.
So I guess for the record, if there are records being taken, can we state that if the neighbors notice that there's renters, if the neighbors notice that there are renters in the house that was built under the context it wouldn't be rental property, what can we do about it?
It's a little bit hard to understand you. You're saying the renters on lot one, is that what you're talking about right now?
If the additional property is owned and built under the understanding that it won't be a rental property.
No.
And it turned, I'm sorry?
We can't do that. We can't tell them they can't have their house and have to move somewhere, and they can't rent their house. We can't tell them that. It's just not allowed.
But earlier you said that was going to be part of the actual
on lot one.
Consideration.
We can do that on lot one because there's two separate houses. That's different because then somebody can start using it as an Airbnb or other things. Lot two is just a single family home lot. As long as the guy falls within falls in on the approved motion for the variances, there's nothing else we can do. Lot two, as Barb indicated, we can do some deed restrictions that those people that are in there now can maybe stay, but they can't be re-rented to something else or other people. We can do that for lot one. Nothing can be done for lot two other than approve the lot, to sell the lot and to build a single-family house on it with the variance to have the reduction of the setbacks of 14 feet, 7 feet from the garage.
And as a single family house, back to what was brought up before, calling the township about code enforcement or the police about noise apply. And there are other properties in that neighborhood, existing single family homes in that neighborhood that are rental also. I don't live
Absolutely.
immediately adjacent to that area. I'm a couple blocks over, but there are the rental properties in the area there, single family houses. But code enforcement, if it's like you can see there's extra people being packed in there, or a whole lot of unrelated people being packed in there, that's what code enforcement is. There's a noise issue, that's what calling the police is about.
Is there anything else?
No, but we'll keep an eye on the neighborhood. Thank you.
No, thank you for commenting. Excuse me, hold on one second. That's fine. Okay, all right. Is any other public comment? No more? Our studio director behind the glass says. Anybody else? Oh, okay. Step up.
No, never mind.
Come on up and get your name and address, be sworn in.
My name is John Galloway. I live at 1714 Makefield Road. We have lived there since 1990. We know.
Yeah, I'm sorry. Thank you. You need to be sworn in.
Sir, do you solemnly swear the testimony about to give will be the truth, so help you God?
Thank you, Barb.
Thank you.
Okay, most of my questions have been answered. I primarily am concerned about the additional load of water usage, sewage, electrical. I'd like to know that all of these elements will be considered with any new construction that will take place on this lot 2. I also would like to know if there's a possibility that because of this new construction on lot 2 and whatever the adjustment has to be made between lots 1 and 2, that it will not negatively impact the property taxes that we now pay, that will be assessed a greater tax variant, whatever that is.
I'm sorry. Go ahead, Mr. Chairman. I apologize.
Maybe it'd be best if I answered.
Okay, thank you.
So, Mr. Galloway, your issue as to the tax assessment,
The tax assessment, that's,
what will happen is once the property is developed, notice is sent to the Board of Assessors office. They will make a determination as to the value of the land and the value of the house, and whoever owns lot 2 will be assessed to pay their respective share of local, county, and school district taxes. It's not like the development of a new house on that lot will be apportioned among the rest of the neighbors. They end up there with their own real estate tax bill.
okay, thank you. And that means there will not be any rollover
No.
or anything that affects the rest.
They're going to be responsible to pay their own tax bill. As far as the issue concerning water usage, sewer usage, and things of that nature, they still have to go through steps to, 1, be in front of the Board of Supervisors for approval of the subdivision, and 2, when they go through construction, they're going to have to submit for various permits and things through the township, all of which they're going to have to provide proof that there's sufficient sewer capacity, that there's sufficient water ability, that there's going to be public water and sewer available. You know, they'll have to contact the electric company. So all those things will happen, but down the line, not as it relates to today's proceeding.
Okay, good. I'd like to know that. The other thing that I am concerned about is because we've been there over 30 years, we see this property, whether we're taking now, it's not our children anymore, it's our grandchildren. We see it's in a less than desirable kind of upkeep. And the fear is that if there are people who are either incapable of managing the property because they live there, or it's nothing that I'm going to go to the police about, but it is something that is, when you look at all of the other properties in Green Acres, you say, why is this, since Mr. Neely passed, there's nothing been done? It's trashy.
So if I may again, if there's an issue, contact the township. There's certain codes in effect, something like a property maintenance code. There's mandatory minimum requirements as to how to maintain property. An easy example is if the grass grows too high and it's not cut, they have to comply and they have to maintain and cut high weeds and grass.
Thank you.
There are certain standards that if there's an issue that it's unkept or unsightly or a problem like that, you notify the township. Now, keep in mind, those are standards. You can't expect the township to enforce the aesthetics of this property comparable to somebody who has it manicured and landscaped. It doesn't work that way.
No, it's just about standards, basics. I mean, I do my own work on my property and it's not perfect, but it's acceptable. The other concern is that, and I believe you covered this, Ms. Kirk, that all of the workers will be properly bonded and certified. Anybody that is doing work on the
It has to
property.
get through the township. for the
Nothing to do with
permit.
us.
Okay. I mean, there's lots of kids around and,
Yeah, we got it. Yeah,
Okay.
Contractors have to have all that. When they go to get a permits, that'll be all,
okay,
and you can inquire about that yourself. They have to post the permits.
okay,
You have to do your part too. We can't just be controlling around. I'm sure they don't have time to do that.
okay. All right, well, thank you very
No,
much.
thank you. Anything else?
No.
Anybody else?
Yeah, it's Lucille Janikova again. When we bought this property 12 years ago, it was a disaster. And the house that now has stone on the front was a clapboard house that hadn't been lived in years and nothing done to it in years. It was in shambles. The same with the other property on Supton Road. So if anybody knows the way I keep my home and those homes, they could see that the upkeep is fabulous. There's nothing that they could complain about. And if they do have a complaint, they can call me. Like I said, the only reason we left the garage the way it was is because we wanted to get this through first and see which direction we were going. And but that will be taken care of.
Okay. I understand. Anybody else? Got to say something? James? What do you want to, what do you want to? Right, there's no boo, where are you going to put it? Right, exactly. Yeah, we have to have a couple. Anybody else? Mrs. Kirk? Anything? Anybody else?
I have nothing further.
Nothing further? Well, now's the time. Okay, take a motion.
No, I'm good down here, Anthony.
All right. You want to make the motion, you want me to make it? You came in late? All right. Appeal number 21-1932, be granted the variance to, for lot number, for the lot tax parcel. Lot number 2 would have a 96-foot width, which would be a 14-foot setback. Am I correct on that? I think I am. Roughly. And the garage would continue to have a 7-foot setback, but it would be knocked down or repaired, whatever's necessary to get it to pass inspection. as far as structural integrity. And we'd also would include in the motion, if approved, in the motion would include Barbara's idea that the two houses on lot one that are currently being used by relatives, as you say, will stay that way and will not be allowed to do that again. Am I correct that that's what the township wants?
I would say
Can we say it like that?
language, if language acceptable to both the township
Okay.
and property owners as to preserve the residential character
Okay.
of the property. How's that?
Sounds
That
good
would-
to me.
Yep.
Okay. Anybody got a second?
Second.
Second? Any discussion? Or no discussion? I'll call for a vote. All those in favor of this variance? Say aye.
Aye.
Aye. All those opposed? Those 3-0.
And just noting on the record that since Matt got here, he's abstaining from the vote, just so it's clear.
Motion passes. Thank you very
Great.
much. Thank you,
Thank
guys.
you very much.
Looks like hanging around, huh?
Yeah, when Mr. Murphy has since joined me, so you get 2 for 1, but just for a continuance, I believe, for the
Wow.
for the next one.
Like the old days in the movies. Get 2
I,
movies.
you
for
know
the
what? I'll if you're lucky, I'll even change my computer so you can see his pretty face. But he's listening and scowling. You can rest assured.
Thank you.
Thank you.
Thank you, Lucio. You can log. We have to stay on for another one, but you can jump off as well as John if you like. You can sit here.
Do you guys need a little more time? Do you asking for a continuance, Ed? Or first of all, how's everything going with the missus?
It's going. It's slow but steady. I think we're making some progress.
Okay. All right. So what's up?
During the day today, Barb and I had an exchange about the effort that we both want to make to see if we can address the township concerns about the Bucks County Smiles application. So we agreed that we would continue tonight's hearing to give both the township and Dr. Faust an opportunity to consult further to see if we can present a plan that satisfies everybody. So I think Barb's there, and we would agree, I think, to request the board grant a continuance until I'm not sure when the first meeting in November is, because normally it falls on election day, right, this year?
November 1st, it'll be the Monday night.
Be the Monday.
Okay.
But if I may, Mr. Murphy, and this is Barbara Kirk, keep in mind your other contested matter has been scheduled to that date on November 1st. So I don't know
Okay.
if you want to try to move this to the second meeting in November.
Barb, whatever you think, that's fine.
If I may, Mr. Majewski, do you think there'll be sufficient time between now and the first meeting of November to sit down with Dr. Faust and his engineers?
The first meeting in November or the second meeting?
First.
I don't know if there's sufficient time for the first meeting. I think the second meeting would be better.
So in order to afford everybody time, I would ask that we just have it on the second meeting in November, if that's acceptable, Mr. Murphy.
Should be the 16th, Barb?
I believe so.
Correct.
Yes,
Okay.
the 16th.
Yes, 16th.
Okay. You just need a motion for that continuance?
Make a motion to continue Appeal 21-1933 to November 16th.
I second that motion.
Any discussion? All those in favor?
Aye.
Aye.
All
Aye.
those opposed? The ayes have it. Granted.
Very good.
Thank you, guys. Good
Thanks,
night.
everyone.
Thank you.
Yeah, I mean, we can do that now, yeah. No, you could, if you're gonna schedule one, you gotta do it now.
Well, the November 1st meeting is a Monday, right?
Correct.
I can't, I teach on Monday nights, so
Yeah,
I'm not
you're
available.
not available, and I believe Pam is not available. Yeah, so we technically, no.
No, not yet.
We technically have the deck matter that was supposed to have a special meeting last week, which we had to unfortunately postpone to the November 1st hearing. But since we're going to need all night for that, we can make another special meeting that everyone could attend, that you could discuss that one specifically on.
We had,
When's the next special meeting? When would that be? We got one the 14th.
Probably
Yeah.
the second week.
Jim, I think you would, do you have an idea of how much we have on the 1st?
what, October 19th, or that's too short.
Okay. And then I guess if you know for the 16th as well.
You're talking about the November, right?
Correct.
We have October 19th, November 1st, November 16th, our next 3 scheduled meetings.
It would have
If
to
there's too much on the docket, then perhaps it needs to be another
Uh,
special date again.
That's going to be a whole another meeting.
Yeah.
It's going to be
And-
two,
and-
it's going to be more than
the
just one
issue-
more meeting. It'll probably be 2
Gonna be
more
at least,
meetings.
right.
And the
So-
issue, oh, I'm sorry.
Oh, I'm sorry. See, if you get the first, whatever the agenda is on that, it's either take that entire agenda for a deck and push, or
We got the attendance problem on the 1st though because of
Oh,
Am not being here, so I don't think that's feasible for.
The,
Deck
the other
for
problem is
attendance.
the week after the 16th is the week of Thanksgiving.
Right.
Yep.
So that's not really a good week.
I think so.
The 19th or the 16th?
The 19th. He went and looked, the next meeting's the 19th.
Oh, on October 19th.
Well,
Do the deck on the October.
October.
19th.
he had asked for a continuance.
For who?
First,
For
right.
Yeah, but if we can,
First won't work because of our time.
No, I understand that, but he had asked for a continuance.
we can do his continuance.
yeah, I think the other issue is that because of everything going on, he might need more time. And we have to confirm if they can even do it on the
It
19th.
does have
So
to
the
talk.
deck would
So
have
I
to be
think
the
the 19th
16th.
would probably not be,
It's too
19th.
soon.
The first won't work because of the board
Attendance,
members.
the attendance
Yeah.
issue.
and the 16th, what do we have again? Do we have a lot?
The 16th, we have the continuance for the Jennings matter,
Oh,
and I believe that's all we have at the moment.
And that's all we have?
Jennings and Fost right now, but Jennings is likely to be a long one too. There's a lot of public comment.
That's gonna be a long night.
Yeah.
So I think we're looking at a meeting off at some
So
point in
I,
November.
so I
Yeah,
think
in
what we
December.
can, what I think what we can do is, I'll try to coordinate with Ed, his witnesses, John Fenningham, his witnesses, and Barb. Make sure that everyone is available. We'll circulate some dates, obviously circulate, confirm with Jim if we can do it on a regular meeting, or if we need to schedule a special meeting. Confirm with the board if it is a special meeting, so that obviously.
Yeah,
you
I
guys-
don't see a regular meeting being available till December.
Correct.
given what was
So,
just
so
said,
it might just be a special meeting. So that's why right now we have time because it's not technically listed till the 1st. And in the meantime, that gives me a few weeks to work with everyone to get a special meeting on the books. And then at the 1st, or even at the next meeting, the 19th, if we have it done in time, we can formally move it, make the motion, and also make the motion to establish the special meeting.
We can do that on the 19th. also.
Yeah, if I can get that done in time, then we can do it at the
All
next
right.
meeting. Yeah.
Sorry.
November 16th
November, we were talking about a 19th of October
for a different
for a
appeal.
different meeting. The 16th will still be the same things, whatever it is.
It'll be Bucks County Smiles will be on November 16th and Jennings.
Come on back. All right, thank you. Is that it?
So with that in mind, you just
Okay.
motion to adjourn.
Motion to adjourn? So moved. Second, all those in favor, aye?
Aye.
Meeting's adjourned. Thank you very much.